This is a Power 98.7 podcast. Now we're talking. Subscribe to Power 98.7 podcasts in iTunes or wherever you get your podcasts. There's more on power987.co.za.
Welcome back. We are joined by a tax legal expert, specialist at Latita Africa, Thomas Lobban. Welcome to Power Talk, and please correct me if I butchered that name. Thomas?
Thanks for having me. Yes, Thomas Lobban. Thanks for having me today.
Okay, thanks very much. I'm sure you were listening to our conversation with the DA.
Yes, interesting chat. A lot of energy there, but good to hear.
Well, I mean, first of all, from a technical parliament process point of view, the Minister of Finance, I don't think I can recall in the last 30 years where something like that happened, and you'll correct me if I am wrong. But procedurally, what is to follow? What are the implications? One, to the fiscal framework. Does it have to be readmitted into Parliament with an amendment, or they just move to the Division of Revenue and Appropriation Bill? What are the legal parliamentary implications of his decision or announcement that 0.5% is now reversed?
Well, you're not wrong that this is an unprecedented move. We haven't seen a race change announced and then at the last minute revoked. So it does raise questions about how practically this is going to be done. As far as parliamentary process is concerned, your previous guest was correct. The appropriation bill and the policy framework do need to go back to the relevant finance committees, usually Standing Committee on Finance, Select Committee on Finance. They need to approve of these adjustments as well as the revised bill to move to Parliament, first national, then the NCOP for approval before it can be gazetted, before it can be assented to by the President and gazetted. So whether they're going to be able to pull that off in an astoundingly short amount of time is a very good question to be asked right now.
But you are speaking about appropriations bill and the Division of Revenue bill. You are not speaking about the fiscal framework. In as far as the tax increase is concerned, the idea that we have always known is that it has to do with the fiscal framework that was adopted. And the question is this lacuna in law. Tax Act already empowers the minister to unilaterally amend tax increases or decreases. So what's about to happen? Is the fiscal framework going back to the House, or they just proceed to Division of Revenue and Appropriation Bill in as far as the Money Bills Act is concerned?
That's a very good question. My understanding of the current court case in which the ruling is being waited for Tuesday, at least in part surrounds this. We go back to Section 7.4 of the VAT Act, which does give the minister the power to alter the VAT rate in terms of Section 7 of that Act. But that power is subject to parliamentary approval. And that change can take place for up to 12 months, again, subject to parliamentary approval within that time. But what happens when Parliament doesn't approve it? You can't take back that has been paid with an increased rate. So does that mean that it's changed back from that point onwards when Parliament does not approve it? It doesn't mean that change shouldn't have been made in the first place. And there we look at the alleged lacuna in the law, and that really is what a lot of these questions surround right now.
On the one hand, the Tax Act really just empowers the minister through a budget vote. That's why all of us received sort of letters in our emails and SMSs even before the fiscal framework was adopted. Basically, what business does is listen to the speech, Once the minister says there's going to be a 2% or a 0.5% VAT increase, they start writing to us that from the 1st of May, be ready to adjust your payments. They don't wait for the fiscal framework. That's the prayers, as I understand, of the DA at the court. I'll come to that, but it doesn't seem to me that that fiscal framework that is adopted, and maybe that's why it's called a framework, it really does not have that much power in relation to this power of the minister in the Tax Act. Am I correct?
I would also understand these as different things, because the VAT Act, what it allows the minister to do is adjust rates, but it does not create an obligation to fit it within the fiscal framework. This remains a parliamentary process. So the one hand does wash the other. They cannot exist in a vacuum, shall I say. So the fact that the VAT rate the increase is being revoked now, that still has a knock-on effect with these other processes that need to happen in order for our new budget and our new year to really move ahead as it should.
Okay, so with the court case, I mean, for the benefit of our listeners, just a basic, I know I've been mentioning some of these prayers, but what is the DA looking for from the court and the EFF?
Yes, of course. So the 0.5% increase, firstly, they want that set aside, and the fiscal framework underpinning it to be unlawful and irrational. Remembering that the fiscal framework is essentially our budgetary blueprint for the year, saying that only Parliament may raise taxes. So the minister's temporary and conditional authority to increase the VAT rate is actually beyond his powers, essentially the executive appropriating the powers of the legislature. So even in light from listening to your previous interview now, they're maintaining their scheme even in light of the U-turn on rate policy. But if I understand the EFF side of things, then we are apolitical as a firm, but to comment on this, they seem to be contending that it violated procedural fairness, demanding at least judicial clarity on the separation of powers and accountability in this case. Again, surrounding the question of the minister, the executive appropriating the powers of the legislature and in changing the law here to the rate change.
What confuses me, if my prayers are the Tax Act is not constitutional, one, therefore, on the basis that it is or it may be declared unconstitutional, suspend the unilateral power of the minister to increase taxes, which he has just done by 0.5 basis point. And then two, there were procedural problems to the adoption. That has nothing to do with the minister. That's Parliament. But if that's your prayer in relation to the minister, what offer can he give you?
That's a very good question. And I, for one, don't exactly know. What I can mention is that this legislation, this statute, Section 7.4 of the VAT Act that's currently in issue, that was only commenced from 2017 onwards. What was the situation, the procedure, and the flow through before then? How did things play out? Was that correct? Was the introduction of this law really necessary, and therefore was it constitutional? The question has never come up before the current issue before us today with that. So it's never been litigated before today.
Yeah, but I'm trying to interrogate here, like the claim the minister made us an offer. What would that offer look like? I mean, in his powers, in the executive, you are saying to the court, suspend the minister's recent decision to increase taxes because that decision is based on an act where he can unilaterally increase taxes. If I'm the Minister of Finance and I'm saying, let me make you an offer, what kind of an offer would I make you which would satisfy you getting an out-of-court settlement?
But that I agree with you in asking the question myself. What would be within the minister's powers to offer beyond just revoking the VAT increase Again, what is within his powers to offer beyond that? He does not himself steer legislation. That is the role of the legislature. So until we see more news on this or an announcement to that effect, we will not know.
Yeah, because I mean, it is very confusing to me as well. It seems to me the offer that you can get based on your arguments is if Parliament says, well, our decision to constitute that parliamentary meeting was wrong procedurally, and therefore the fiscal framework falls apart. But even in that case, Thomas, the power of the minister to unilaterally take a decision on increasing taxes stays. You can't be given an offer out of court if you are in that position. If your prayers are based on the decision being changed or being declared unconstitutional. Help me with the law here. What happens in courts, in offline? What happens? I mean, because my cause here is there's no offer that the minister could have ever offered to the DA in the first place.
It's a proper head scratcher, isn't it?
Come again?
It's a proper head scratcher, isn't it?
Yeah, I'm not understanding what offer the minister could have ever given. I mean, it doesn't make any sense. He has no... He has nothing to offer because he has to basically amend the act. He has to say, yes, indeed, I acted unconstitutionally, I concede. But you wouldn't be able to get that off the court. You need a court order that says those powers are unconstitutional, which kicks off an amendment to the Tax Act.
The irony of this is that, of course, a lot of the legal fraternity, my colleagues that I've spoken to, their belief is the same as mine. That the most likely way that this VAT increase will be scrapped before the deadline is actually by way of order of court, whether it's an interim order or a final order. The latter being unlikely. Beyond that, an offer from the minister, what would that entail? Would that entail proposing a change to the wording of that law? But is that something that can be done retrospectively? It can't be done.
But that is not in the power of the minister. The minister is in the executive, is not in the legislature.
Correct. So it's something that still has to go through a proper parliamentary process. And again, that takes time. And whether he can have it proposed, that's not a guarantee that that's the way the law will end up being enacted if a change is made in any event. So again, we return to the same question that we both asked. What would that offer reasonably entail? And is it practically, legally even possible to guarantee that it'll play out in that way? So I, for one, want to see the order of the court to see exactly what the finding is in the first place and the effect that it'll have on both the issues in dispute and this VAT rate increase that we're currently facing as of next week, if it's not reversed in time properly.
Now, let us say, hypothetically, the court grants the prayers of both the EFF and the DA. It would mean that the whole process, even including the fact of the reversal of the 0.5% increase, were all illegal. Because on what basis is the minister changing a decision that was made in Parliament through the fiscal framework?
Again, there could be any reason. They could find
I'm not sure why people who are in court would be celebrating the minister unilaterally again changing the 0.5% VAT if in the court they are saying the minister's unilateral decision-making is wrong.
I think what we need to be very careful to do is think through messaging and posturing and actually keep to the legal question before us. Is what we're dealing with, the VAT rate change, before the revocation, Section 7.4, is that provision that allows him to unilaterally make that decision by way of an announcement, is that constitutional? Does it override or does it go beyond his powers?
Yeah.
In relation to Parliament. And then, the questions that may not be answered by the court if it makes a ruling on this, that decision being subject to parliamentary approval, when is that approval required? Is it required before it becomes effective? The law says that it may be in effect for up to 12 months. But again, as I mentioned earlier, what happens when Parliament does not provide that approval? Does it get revoked retroactively? With something like that, how do you go into each shop, to each consumer, and see how much VAT they pay in excess of what should have been paid if this is revoked with retroactive effect? It just cannot be done. Does it mean that that rate change should never have happened in the first place? This is why it's important for a question like this to be heard in court and for the law to be clarified properly. And if it is a provision that is unconstitutional, then it's for the court to make a finding on the change that must be done, the scope of that change, and for Parliament to make that happen in a responsible manner. But what we cannot have, if it is found to be an overreach of the executive's powers, we cannot allow that to continue.
But if the court does grant the prayers of the DA, what do you anticipate would be the implications? What's going to happen if the court says the tax act is unconstitutional, procedurally the committee was wrong and Parliament shouldn't have passed the fiscal framework? What are the implications of that?
Well, the High Court has wide powers, and foreseeably any judgment it makes will be heard higher. This is something that could go up all the way to constitutional courts, especially if finding is made on constitutional grounds here. They could make the finding that the change was unlawful and unconstitutional. The court would be empowered to freeze that change. Alternatively, the court could merely order, if it is a finding in favor of the applicants, they could make the order that the law must be amended. And again, whether that's with retrospective effect, which is likely if it is deemed unconstitutional, that then falls to Parliament to carry out the order of the court and to change the wording of that law or to repeal it altogether. Again, I repeat, this law did not exist in force at least until 2017. So foreseeably, if the law is struck, repealed, then we would return to what the position was before then. What was the reason for the introduction of this law in the first place? Perhaps that's a question that people should ask as well when considering this overall issue.
Okay, we'll wait for the Tuesday judgment, which is obviously just at this stage going to rule on the basis of Part A, I suppose, of the case. But thanks very much, Thomas, and have an excellent long weekend.
You've been listening to a Power 98.7 podcast. For more podcasts, visit power987.co.za or subscribe wherever you get your podcasts.